So this segment is about winning adjudication trials. And by the title, you might think that that's something that can regularly be done, right? We're very optimistic about this. And it can be done, but even under the best circumstances with the best facts, the truth is that once that petition train is going, it's not likely that jurisdiction is not going to occur. So what I mean by winning is, we need a little bit of a paradigm shift in terms of how we view winning. We have to set some realistic expectations. And winning can be that you would get a really good plea. Winning can be that you manage to keep out some evidence that is really, really bad for your client, that has absolutely nothing to do with your client's ability to safely care for the child. Winning can be a lot of things, and it's going to largely be influenced by your client's expectations. So keep that in mind. So choice points, to plea or not to plea. We had a little bit of a discussion earlier about whether to waive the preliminary hearing, and this is a comparable discussion that you need to make with your client. And going to that point about setting your client's realistic expectations, you're going to review the evidence with your client and advise the client. That's part of our responsibility. We're attorneys and counselors, so you have to advise the client on what's a realistic outcome and get your client to understand what the process is. The type of plea, admissions versus no contest, plea to an amended petition or not, plea before trial, plea before judge, jury, or referee. I said plea, I meant to say trial. Appealing adverse decisions and remaining client-centered at all times. Those are the things that you want to keep in mind. Before you make any decisions, you want to review the petition closely. We already talked about how to determine what information you need to get. Developing the investigation plan relates to this. Obtaining and reviewing discovery, we really went over much of, all of those things actually. Why plea? Weak case. You want to avoid really, really bad facts coming in, as I talked about just a minute ago. So you're controlling the flow of information. You want to create momentum, because the truth is that if you demand a trial, and in many instances you should, but you have to demand it with the full understanding that it is going to slow up momentum of the case. And if the situation confronting your client is one that can very quickly be remedied, you might want to consider not going to trial, so that you can avoid unnecessary delays and focus on the future, not the past. Our clients, I believe it's because they so infrequently have a voice or feel like they're being listened to, they get kind of stuck in the past and about what did or didn't happen. And in order to be able to effectively represent them, you have to, in a very compassionate way, kind of usher them beyond the past and get them to look for the future. And I'm not suggesting that this is easy, but it's something that you should constantly be endeavoring to do. So we went over the reasons why you might not want to go to trial, but why might you go to trial if you have a really, really strong case? You know, some clients, irrespective of whether the case is strong, and they may even know that they're going to lose, they want you to go based on principle. You'd like an opportunity to present your client's story to the court. Sometimes if that happens, even as the client is witnessing his or her story unfolding in court, it makes that client a lot more amenable to whatever services are going to be imposed on the client, because they feel like they've had their say. You want to influence how the court and others perceive your client, and that's something that you want to do even if you lose at trial. And ultimately, as with any decision that's of import in these proceedings, it's your client's. So your client has to buy in if you are going to go to trial or not.
Tracy, I wonder though, does anybody here plead people to immediate termination petitions? I mean, that's real high risk.
Does somebody do that?
Sometimes the LGAL will try to convince you to, you know, they want to cut to the chase, so that they'll come instead of the prosecutor suggest it, or they'll suggest it, and then just have a best interest hearing. I don't do it, because why do you
Oh.
make things convenient if you're not going to remove the request to terminate?
Yeah. So
I'd say
in
you have to fight at a trial to get the termination request off the table by settlement. You have to say, I know, we're trying this.
mhm.
If you want to get termination off the table, your best strategy is to make them think, yeah, we're going to go through this trial. You put that kid up on the stand, go ahead right now. You know, and they might deal. In fact, they most often do. They will take it off.
Well, the reality is that I've heard someone, more than one someone, describe termination of parental rights as the civil equivalent of the death penalty. So if you have absolutely nothing to lose, it makes no sense. It actually makes more sense, especially if you know your client's going to lose. It might make more sense to go to trial just so that your client can have some closure, so that your client can hear the evidence that's being, because sometimes our clients are in denial. I know that that's not often, but sometimes our clients are in denial. And in those instances where they see this evidence unfolding, it can do not only them, but their relationship with family members and sometimes even with their children down the road a world of good.
And I only do it if I feel that,
I have clients that actually want the rights terminated, and I okay that. That's good.
So, well,
Yeah, so it does happen, because you have clients like, I want nothing to do with that child.
they can't release if if there's not going to be an adoption. So if the other parent's rights aren't being terminated, then your client's release shouldn't be allowed. I know that happens in some places. It doesn't happen in Wayne County because the assistant attorneys general know that, and the lawyers guardian ad litem know that. It's, well, see, the adoption.
To release in our code is in the adoption code.
when the adoption,
So it's set, so there's actually no process in the juvenile code there's no language about releasing the rights.
Yeah.
So if people do it,
A lot of people may want to do it.
Grace of the juvenile judge, generally after a termination petition is filed.
but there's just no mechanism. I mean, like, you can consent to the termination petition,
Right.
almost like plea to the petition, and not fight it and have them sort of put on some basic proofs. But there's this idea that if a kid's with a parent that we're releasing doesn't really, there's just no mechanism to do it under our laws.
Wait, just so I'm clear, so you're saying that because I've had a case where you had both parents wanted to release, but are you saying they can only release if there's an adoption set? Because,
If the goal is adoption, if they're releasing their rights to the agency, that's
Okay.
totally permissible. But if a kid's like placed in the custody of another parent, and then your client wants to release their rights,
right,
it's they can't under the adoption code.
right. I had one where they
Yeah.
Because
both,
the kid can't be made.
I had one where they
Yes.
both released because the child had such severe
Yeah, and that's
issues,
permissible.
and they were a young couple, and it was
Yeah.
there was a nurse that was interested in adopting because the child was blind and just had some severe issues.
Yeah, so
So
that's permissible.
Yeah.
Yes, exactly. So then the agency would get the rights to the child to figure out where to place the child.
Yeah, so if the release isn't going to result in an adoption, which would be the case if both parents are not releasing, then you can't do it.
See, yeah, that didn't happen in my world.
You've got an interesting world.
There actually is a case under the footnote.
They don't one parent, they don't like to do it often, but they will.
No, they can terminate on
Yeah,
one
that's
parent.
what I'm talking about. They terminate on one parent, and I'll have a client come in, I just don't want anything to do with that child, let's stipulate to the termination petition, we're done.
Yeah, that's it. If the other parent's okay, if the parent that hasn't been adjudicated or isn't getting terminated, they're okay with it.
Yeah. Okay, so what the rule for pleas is MCR 3.971. and you have to make the determination if you're going to plead, whether it's going to be admitting to allegations in the petition or pleading no contest. And where am I? Remember that if your client is pleading to allegations in the petition or making admissions to allegations in the petition, those admissions have to be to something that's not only true, but that meets the statutory grounds for jurisdiction under MCL 712A2B. And everybody knows this. Everybody does. But in practice, it's rarely respected. And you have, and in fairness, especially in the larger counties, and I'm speaking specifically now about Wayne, there's such a high volume. And so there tends to be this kind of conveyor belt thing that happens with these cases. But just because something is in the petition and it's true doesn't mean that it meets the statutory basis, and that was something that Vivek pointed out earlier. You see all the time, dad admits that he didn't pay child support. Well, unless you can make out a case for dad's failure to pay child support coming under one of those specific 2B provisions, and I can't see how that alone would, then you don't have a legally sufficient plea. And just like in the criminal law, the plea needs to be factually and legally sufficient under the statute.
Well, I've seen people make the argument that failure to pay child support does come under one, where you fail to provide the proper care, custody, support, education, blah, 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 blah. But support, I've seen people argue that.
I think the DHS policy manual says they're not supposed to be bringing child support petitions for neglect.
They don't bring
So-
it by themselves, they'll add it in when they have a very thin petition.
So the operative language there, though, is when able to do so.
Yes. And there's only, and when able to do so is there's only one, I've only found one case on that. I think it's unpublished, but that when able to do so is very seldom a defense at trial. I hear
But
you.
why is that? Because we're not raising it.
Yeah, it is in the juvenile cases, just not the child support cases.
So ask the court's permission, if you are entering a plea, to voir dire your client, because then you control the evidence that's coming in. A lot of times our clients, really, it's admirable in an effort to just be forthcoming, to get things moving. They say all kinds of things that sometimes aren't even relevant, but they shape the way that the jurist and the other stakeholders in the proceedings views the client. And it's ultimately going to be held against the client, even if it isn't relevant. So you want to be sure that when you're allowing a client to plead, I shouldn't say allowing because it really is the client's decision, right? Right, Kim? You want to be sure that you keep it very succinct, that you focus on the statute and apply the facts to the statute that are relevant.
Dude, what do you think? I mean, I kind of learned this the hard way. I don't kind of like no contest pleas. Sometimes they're used because it's more agreeable to the client. They might have to get up and put a factual basis on the record. But the problem with using like a police report or a CPS report, all these other things come into the record because you've allowed it to. And you can't undo it once you've allowed it to be a basis for factual. So I try to advise clients, let's work on the language of you putting the factual basis on the record.
Well, going back to something you were saying earlier, Kim, the client can't just, because he or she doesn't want to testify, enter a no contest plea. You need to be able to establish that.
Prosecutor wants a conviction.
Well, you need to be able to establish, you got to establish a legal basis for a no contest plea. Otherwise, everybody would be trying to do it, right? There has to be some real criminal liability or even civil liability that's implicated.
Lack of
Central
memory.
registry, central registry, because you might have a better central registry argument under the new law if you put no contest, because there is civil liability, it's called getting on the central registry. Possibly, it might help you with the new law that says kind of that if you were found adjudicated, that you can't get off the registry, but you might kind of look at that language a little bit and say, hey, well, maybe with the no contest plea, that might be different.
That's an interesting approach.
Which
Okay.
applies to everybody, since everybody gets put on the central registry before they ever have a trial or anything.
So, but going to, still on no contest plea, and going back to what you were saying, Kim, about the police report and the the CPS report, are those admissible?
They put them in the court file and the Court of Appeals has them.
I try to keep them out.
So for a no contest plea, don't we have to, even though the client isn't testifying,
Exception.
we've got to have a legal basis for getting those things in, no matter what the basis is for the no contest plea. It has to be a legal basis for getting it in, evidentiary basis, right?
You would agree, as the respondent, that the court can use the police report or the CPS report. They have to have a factual basis, so if you're not going to give it, you will relent to that. You agree to allow the court to use it as a factual basis.
Now, I'm not certain about this, but my take on that would be that they would need to use something else, like somebody's testimony, because, and we allow this all the time, right? Somebody, please share with me if you know that this has been litigated, but the police report and the CPS report are not, they're not admissible evidence.
No, but they can support a plea.
But they can support a factual basis.
Yes.
Okay.
But your client
It's
can
done
show
all the time.
Yeah, if we consent to it.
Yes, I'm saying
Yeah.
the client is consenting,
Yeah.
that's why.
That's what you're saying, okay.
There's no contest.
Yeah.
Where did we leave off? Okay. So when we're negotiating plea, we want to be sure that all of the, and I alluded to this a moment ago, there's a lot of stuff that's in the petition that is not relevant at all. And you want to focus everybody's attention on the things that are relevant, and you want to strike all the irrelevant allegations, even if you have to do it formally on the record. Now, I've only had one or two instances where I've asked the court to strike allegations, and much to my pleasant surprise, they did do it, because the court read the allegations, realized even if they were true, there was no way that that they would be relevant to the ultimate determination as to whether the case came under the jurisdictional standard. Right, the basics for the adjudication trial are right to trial before a judge, jury, or referee. Department has to prove by preponderance of evidence that one or more of the allegations is true and establishes the jurisdictional grounds. We talked about that. And the rules of evidence do apply. So that means that we have to be experts in the rules of evidence. And I'll tell you that even if you're half an expert, you're going to be probably 10 feet ahead of the next lawyer in that courtroom. Because most lawyers period, but certainly in child welfare, they don't bother to learn the rules of evidence.
Well, but on top of that, they shouldn't pay you on the day you get to cross-examine a caseworker on a stand when the evidence rules apply, because they can't testify within the evidence rules. It's almost like they don't know how. They really, honestly, most of them don't know how. And
Because they haven't been forced to do it.
I'm concerned about something, or I kind of thought this, or someone referred this to us and told us this is what happened on the CPS hotline. It's hearsay after lack of foundation, after no expert opinion backup. I mean, you name it.
And hearsay
You can
within
have a
hearsay.
full lookout, and in 10 minutes, have them violate maybe half the rules. I'm not kidding. So one reason I think it's fun to do trials is, even if you're going to lose, is that you really shake up the caseworkers really bad, because they don't know
Or
how
they
to
are
testify.
afraid to get on the
Well, not only that, but if you know the rules of evidence, it's going to be, and you're applying them, it's going to be evident very quickly in the trial that you are the expert in the courtroom. And the jurist is going to begin to defer to you.
And they have to
I've,
rule on the rules of
they have to rule on it. They know, especially. And in fairness to the jurist, you know, they're relying on the attorneys to tell them what the law is. You know, we learn in law school that it's your job to tell the judge what the law is. It's the judge's job to apply the law. That's probably not accurate, but it's in practice what happens.
fall apart when you see these petitions that really don't have admissible evidence to back them up, or they don't want to put it on, or they didn't bring it to court that
But if they know what we're doing every time we go into a courtroom is we're representing a client in two cases. We're representing the client that's in the case right there at hand, and we're representing the next client in the next case before that same jurist and those other same attorneys. And so if they know that you're coming into the courtroom and you know the rules of evidence, that changes the game. They're going to want to negotiate reasonably. They may even want to pull certain allegations out of the petition. They may even want to withdraw the petition. If they know, and by they I mean the opposing counsel, if they know that you know the rules of evidence, because they know that they don't.
I'll say this too, like when you were talking about the trials, like when I was first out of Washington County, I think if you have an issue that you think is like a jury would see differently, then some of the jurors may just rubber stamp, and judges and referees just may rubber stamp. And taking it before a jury can make a big difference. Like
Mm-hmm.
I had 3 parental discipline trials. I took them to jury and we got good results every time.
Mm-hmm.
If we'd gone before the jurist or the referee, I don't think we would have gotten the same results.
I don't know anybody who's taken a parental discipline trial, a parental discipline issue to trial in Wayne County and has lost with a jury. Where that doesn't happen. The jury. That's exactly the point. That's exactly the point.
4% a year, it's ridiculous, we're not asking for them enough. I did a study on it a few years ago to try and get the jury trial rule amended, but I looked at it and it's amazing, about 2/3 of the cases actually do go to trial, but almost all of those are bench trials.
But even if you,
Like in abuse cases,
even if they don't go to trial, if you demand a jury, that case is very likely going to plead favorably.
because some counties are really scared, some individual judges don't know how to don't want to do the trials.
It's more work.
I'll just say in my county, I have a very conservative jury pool. In discipline cases, and I'm not talking about physical, like, if you beat your child and marks all over them, you're not gonna win that. Slap
Nor
them,
should you.
I
Yeah.
think I could win that in Washington County, but these other NA cases, they do not play well in front of the jury as opposed to the judge. So that's typically why I'm asking for a judge trial. I used to have, before I got the present trial, judge, I used to ask for more jury trial.
Well, you have to know who you're trying your case in front of. And if you don't know the judge well, you ask someone who's been before that judge a lot. Because, like I said earlier, judges and referees are people. They have idiosyncrasies and tendencies and biases just like everybody else. And you can use that information to the advantage of your client.
Well, I think the parent attorney community is kind of stepping up on getting more adjudication trials done, especially more jury trials, and people are winning them, some of them. You're not gonna win every one. But if you use that, do you want the government in their life? Do you think these people deserve the government in their life for this? You know?
Right.
Come on, people, that's what this is about.
Yeah.
Mm-hmm.
And people have won that argument.
Yeah.
We have a very good appealing area of law, believe it or not, in adjudication trial.
Yeah.
As long as nobody got bad hurt. As long as nobody got bad hurt.
Right.
You got a
Right.
trial case.
Yep. So we've actually already gone through each one of these steps before trial earlier. So evidentiary issues. where to focus. You're going to litigate the facts that are drawn from the language of the statute. I've said that probably 3 times already, but I could say it over and over and over again because it really can't be understated. One of the things that comes up is the child statement under 10. In Wayne County, I think we do a pretty good job of consistently having the hearing before the trial. The problem, though, is that the hearing is immediately before the trial. And so if you have a hearing immediately before the trial as to whether some pretty critical evidence is going to go into trial, you can't be prepared for trial. So if the judge is insisting on having this hearing immediately before the trial, you should be asking for a different date for the trial. And make sure you ask for it on the record and let the judge deny it. Because you can't really meaningfully prepare if you don't know what evidence
Well, you
is
can't
going to
get
be
an
coming
expert.
in.
A lot of times you want an expert on tender years because they crapped out the interview, it was really bad, and you need to get an expert, but why go out and ask for an expert if you're gonna win the tender years motion, right?
Right.
So, I had somebody I know in Jackson County recently, that was his reason for adjournment. Okay, you did this the day of trial, judge, well, I need an expert now, because the ruling went against me, give me my expert, and let's get the adjournment.
And this requirement for adequate indicia of trustworthiness, litigate that. You know, don't just assume that the jurist is going to think that the circumstances surrounding the child's statement make the statement trustworthy. We really should be litigating that a lot more, I think. So minor parents in poverty cases, I think, really are largely based on what in, is it Yvonne? What Yvonne was describing earlier as this notion of dependency cases. Here in Michigan, we don't call NA cases dependency cases. We call them NA cases, or child welfare cases, or child protection cases.
Dependency jurisdiction statute.
Now we do.
2B3A through D, that's dependency. And there is a distinction in Michigan law in dependency proceedings.
2B3, say it again, Kim, 2B3.
712A.2B3, A through D.
Oh, that's the new statute.
Oh, the sexual
It's the,
victimization.
it's the, yeah.
No,
new-
that's
it is.
dependency.
Yeah,
Oh, yeah.
it's new, very new.
Just be home, yeah.
Yeah,
Oh, wait,
you're
so
absolutely
somebody clarify this, because where I'm from, it's all the same.
Yeah.
Well, it's when you don't necessarily have a neglectful guardian or parent, but you still have a person who's dependent. So for instance, I just did a dependency trial yesterday. And the minor, mother was dead, the father had been terminated, and the newly adopted mother had been deceased. And the guardian didn't want to be guardian anymore. So guardianship was terminated. This girl had no legal parents, neglectful or otherwise, but she was still a dependent. So we did a dependency trial based on 2B3.
So when was the statute enacted? Because we need to correct this slide. Well, I need to correct the slide. When was it enacted? Do you know?
That's not the sexual trafficking law. It's a different.
It was part of
There
it.
is some sexual stuff in there
It
too,
is.
but it also covers
a sexual-
areas
it is.
where a child is, A through D gives
It
you
goes
a lot of
broader
options.
though, Betsy, than
No
sexual
proper
violence
care
as
and
well.
custody is
Mhm.
right. So it's more than just the sexual.
It's the no-fault jurisdiction.
Correct.
So amend your,
Could use it.
Um,
If there's appropriate cases, then when it could be used, like for example, crazy adopted kid wants to kill the family, and the parents go, please, help us, take it. It's not like they're bad parents, but
Yeah.
they're dangerous to the other kids, and I think we can use it.
well, my point for, and thank you for sharing that, Kim, because I did not know that. Amend your slides to include MCL 712A.2B3. But my point here is still the point that just because someone is a minor and just because someone is poor doesn't meet the statutory basis, even under what you've described as the new dependency statute. It may be called a dependency statute, but if someone is a minor, for instance, I have a client right now who's 17 years old. He's going to school. He wanted placement of his child. He was a respondent on the petition because He was a minor and unable to care for himself. That's what the allegations in the petition were. And trial counsel didn't challenge whether he could actually provide a home for his child. And he could provide a home. He was just living with his mother. Well, lots of adults live with other people. You know, living with someone else doesn't, and depending on someone else doesn't mean that you are an unfit parent. I mean, someone might argue that I depend on my husband, maybe a little bit too much. But my point is that we should be challenging these just very ingrained assertions that if someone is a minor, their child automatically is eligible for wardship. If someone is...
How did that even come into the system? He was living with his child at his parents' home?
No, actually, the mother was living with him and his mother. The mother's a minor too.
Both parents.
But so how did the adult father how did it come into the system?
Because the mother left and went back to her father's home, and her father abused her. And so her child was brought in, and the minor father wanted the child to be placed back with him with him and his mother, and the court said no. So we talked about People v. Tennyson already. Common evidentiary issues, relevance. I love relevance because it's just something that you can...
Criminality is not enough?
That was Tennyson.
Criminality and...
Yep.
There's Henry case law as well. Henry White, Henry Root, or Henry Mason support that. There's Supreme Court cases having to do with neglect and abuse.
Yep. So always, relevance seems, it seems to just be a given. Everyone just assumes that anything that's in the petition is being supported by relevant evidence. And you really have to challenge whether it's relevant. Challenge the foundation, because if hearsay and foundation are very closely linked, but if you can't tell whether a witness has personal knowledge, or if you're clear that a witness doesn't have personal knowledge, then not only is it hearsay, but it lacks foundation. So for a direct exam, you want to use non-leading questions. Let the witness tell a story. We talked about that a little earlier. Start questions with who, what, where, when. And I wouldn't necessarily say how. I've been rethinking how and why, because, I'm switching up now. This is direct examination, so you do ask how and why. You don't ask it on cross. You might not like the answer that you get. But the point is elicit details. And what I tell clients is, just get up there, because they're nervous. No matter how well you try to prepare a client, the client is going to want to tell his or her story in the way they feel comfortable telling it. And I tell them, I'll allow you to do that, but if I object, just stop talking. And I won't say what else I'll tell them, because we have mixed company. Did I do that already? No, this is for cross. Ask leading questions. Don't ask a question you don't know the answer to. Don't ever do that. Base your cross-examination questions on reports written by the witnesses, because these are their words, and they have to back up what they've already said. One fact per question or statement. So these are some examples of a cross-examination, but you can read that later. Avoid one too many questions. You don't want to ask an adverse witness a conclusory question, because everything that has led up to that question might be going in your favor. But if you ask, well, wouldn't you agree that my client is an excellent parent? Aren't you just asking the witness to say, no, I don't agree with that, because they don't agree with it? And here's an impeachment script that you can read at your leisure. So, in your closing argument, I think one of the critical strategies to employ is to cite the statute and read it verbatim. Because again, especially in high volume counties, there are so many cases that come through, and the jurist is just expecting each case to be handled pretty much the same way every time. You'll hear, well, this is how we've always done it. In child welfare, I think we all are guilty of the practice of custom as opposed to the practice of law. The statute is the law. If you read the statute verbatim, it's going to make the jurist think about whether the evidence does actually meet the standard that's outlined in the statute. And if you...
I'll give you the most common example that is the violation, and we all got to start thinking that marks and bruises alone do not constitute child abuse. So,
we,
it's a different thing than you've ever heard of.
we've got just a couple more slides, but the only thing that I would add to this discussion is one really good guide for determining whether something is cruel is how the child views it. And how the child views it. So for the example of the black eye, I think a child, even though it's not permanent damage, the child will probably be pretty humiliated by that. And so I think an argument could be made for cruelty if the parent meant to do it. So the distinction often falls between what the parent's intent was. If the parent was trying to discipline the child and accidentally elbowed the child and gave him a black eye, that's different than if the parent struck the child in the eye. So you've got to argue the facts. So if you lose your adjudication, I don't know when this would happen, but if you lose it, as Vivek said earlier, you have a right to appeal it in the original dispositional order. The problem about appealing these cases is that by the time it makes it through the Court of Appeals, and maybe even to the Supreme Court, where however far it's going to go, the case is probably over. So you got a mootness issue. And they're very labor intensive. So you want to talk to your client about and I had a conversation just last week with a client about this. He has a really good case for appealing his dispositional order. But the way the case is progressing looks like he'll probably, if he doesn't win, it looks like the case is going to be over one way or the other, and he and the mom are going to be fighting it out in the domestic relations division over custody. So you have to consider how much time it's going to take and consider the impact that it will have on momentum in the case.
Yeah, well, both my corporal punishment cases did get mooted out in the Court of Appeals. Well, the one outside the other got mooted out because it was done. But I don't think they can moot them anymore because they have a central registry consequence now. If you're adjudicated, you will stay on the registry for at least 10 years. So it seems to me that avoids the mootness problem.
That's a good point. We do have a new central registry law that everybody should be aware of, and that's to what Betsy is alluding.
Tracy, could I ask you a question about your slide,
Mhm.
the former one?
Which one? Mm-hmm.
You said appeal of the initial dispositional order. You're talking about the adjudication order?
No, the dispositional order that's issued at the first
At the
dispositional hearing.
So you can appeal the adjudication, but not the adjudication order. You appeal the adjudication after the dispositional order. So you can. So it's comparable to the criminal context where you can appeal both the conviction and sentence after the sentencing.
And just to clarify the language, I mean, it's the appeal as of right.
Yes.
Right, so you have the appeal as of right that stems from the initial dispositional order. You can technically appeal any order by application to the Court of Appeals. They just don't have to hear that appeal. But if you appeal the initial disposition order, which can include the adjudication, their decision in there, they have to decide it on the merits.
So we actually already talked about much of this, just basically that non-respondent parents against whom no allegations of unfitness have been made have certain entitlements, and Vivek highlighted the fact that they're entitled to have the physical care and custody of the child, but I would also argue that they're entitled to decision-making with respect to that child. Right, Vivek?